Social media trial is underway right now in Los Angeles. The plaintiffs, who include more than 350 families in 250 school districts, claim that platforms are addictive and harmful.
And the head of Instagram testified earlier this week when asked about a specific example of a girl who spent 16 hours a day on the platform. He called it problematic, not addictive, though. Northwestern law professor Jim Speta joins us now with answers to some of our questions this afternoon. I appreciate you, sir.
Hello.
Okay. Well, big question in this case is whether Instagram and YouTube actually caused any harm. Some of the plaintiffs here were struggling with their mental health before they started using the platform. So I guess the question becomes, where is the line? When is social media responsible for it?
Well, social media will be responsible if the plaintiffs can show that the particular decisions that the platforms made about how to design and provide their products did cause the addiction and did cause the mental health problems. As you've said, the causation piece here is the most difficult piece, and that's often the case in torts. Sometimes we don't know why people got cancer or had other injuries, and that's going to be an issue in this case as well.
Yeah, people are focused on this because it's one of the rare opportunities where you have the head of Instagram under oath testifying. But, I think back to, the cigarette days and all the lawsuits against the tobacco companies. I guess you could take it a step further and say, isn't this a bit like suing a vodka company because you became an alcoholic? From a legal perspective, talk to us a little bit about where the line is.
The line is difficult to draw, but the line will be drawn on the basis of whether the jury thinks that the decisions that the defendants have made are reasonable or not, whether they are more in the nature of designing a product that people like. All companies try to design products that people like, or whether they're designing a product that they know and intend to be addictive. Cigarettes is a great example. When you said vodka, I worried a little bit here because we're focused on teenagers. We don't think the same as we might about adults who are drinking. Here it's teenagers. And there's evidence that the social media companies specifically target teenagers for overuse of their products.
Okay, so interesting. I want to talk to you about big picture and where we go from here. Of course, a lot of the conversation lies on regulating, right? How do you regulate this technology? So do you regulate it or do you deny access to kids altogether? Is there an answer?
We don't know what the right answer is right now. Some countries, Australia, are experimenting with denying access. Certainly, we have seen a trend in the United States in some school districts to take away phones during school times in order to decrease the diversion of attention, et cetera. So we're experimenting with the things that we think might help the situation. But on regulation, one of the important contexts for these cases is that there is already a law that provides a lot of protection to social media companies. And it's a background issue in this case. We call it Section 230 of the Communications Act. And the real question for the law right now is whether that immunity is too broad and whether it ought to be changed. And I think the things we're going to learn in this suit are going to be important in thinking about that question.
All right, Northwestern law professor Jim Speta, we appreciate your insight. Thanks for joining us on a Friday.
Appreciate being here.
All right.